So a big welcome to everyone who joined us today for this webinar on the basics of data protection issues in business development and impact of Brexit. So I'm going to leave the floor in a minute to my much more competent colleagues, Rachel and Nora, to talk you through that. But just as a brief background introduction, whilst I'm still letting people in, I just wanted to run through some housekeeping rules. So probably noticed that you are all on mute as joining the meeting. You can unmute yourself if you want to speak, but I would just ask if during Nora's presentation you can remain muted and with camera off, so then it's just easier when we run through the slides. We obviously want to have the webinar as interactive as possible, so if during the talk there are any questions or points you would like to raise, you are more than welcome to do so, but perhaps just drop a quick message in the chat box and then we'll let you obviously raise this question and then Nora will address as they come through. Last point is the meeting is recorded, as you probably saw from the red button at the top. So that's just for your information, and it's good because you can have access to the recording afterwards. So without further ado, I'm going to leave the floor to Rachel Bradley, who is a partner specialized in life sciences at Pennington's Manchester Cooper. She will introduce you to the session and the further session we will probably run on this topic and others on legal aspects in life science. So Rachel, over to you.
Thanks, Aline. Good afternoon, everyone, and welcome to this session on data protection today. So as Aline said, my name is Rachel Bradley. I'm a partner at in the IP, IT and commercial team at Pennington's Manchester Cooper based in Cambridge. I work very closely with lots of life science businesses on IP, commercial and data issues. I would like to introduce you to my colleague Nora Pook. She is a senior associate in my team. She's based in Oxford, and Nora specialises in working on IT agreements predominantly and other commercial agreements, and also data protection. And she has significant experience in advising many businesses and organisations in different sectors on data protection issues, in particular and including life sciences sector. And she advises on a full range of data protection compliance, including drafting policies, advising on issues to do with marketing, data sharing and more. And Nora will be presenting to you on data protection today. But just before she starts, just to give a brief introduction, so the seminar is intended to be an intro into the basics of data protection. Of course, many of you will be familiar with it, no doubt, since at least since 2018 when GDPR came in. But this session is intended to focus on some of the kind of key underlying principles and concepts that organisations need to comply with a focus on giving some practical points and to go over some of the recent changes in legislation relating to international data transfers. As Aline mentioned, this is supposed to be the first in a short series of seminars on data protection that we'll be giving in collaboration with One Nucleus. And our aim is to do a further session, while this one goes well, of course, and people are interested, to do a further session later this year, which will focus more on data protection issues relating to patient data and health data. So that's the plan later this year. But anyway, without further ado, I will hand you over to Nora to do the session today. Just to mention, as Aline said, if you do have any questions during the session, please do drop your questions in the chat box. Hopefully there will be time at the end as well if you'd prefer to ask them at the end of the session. Many thanks.
Hello everyone, thanks Rachel. So yeah, as Rachel was saying, we're just going to have sort of a brief overview on sort of data protection and then focusing on marketing and business development activities in respect of sort of any sort of data protection requirements, and then going on to international data transfers and the impact of Brexit. So I thought it would be useful just to have a quick summary of the relevant legislation. So with the end of the transition period, we've now got the UK GDPR in place that sits alongside the Data Protection Act and also PECA, which is the Privacy and Electronic Communications Regulations. I'm sure you're all already aware with PECA. And we still have the EU GDPR, which still applies, where it has extraterritorial effect going forward. I thought it was going to be sort of quite helpful, sort of just to sort of do a quick overview of sort of what is personal data, but also some key definitions, just to sort of to remind ourselves what is covered by the data protection laws. So personal data includes anything that from which a person can be identified or is identifiable from, and that can be either directly or indirectly in combination with other data. And I think it's important to remember that it doesn't just cover private information, but also information that's publicly available. So for example, if you've got information on Companies House, that is public information, but still directors' names will still be personal data. Or another example is information on a website, that is still someone's contact details on the website, still personal data, even though it's publicly available. And then obviously, in addition to sort of the standard personal data, we've obviously also got special category data, but I don't think that's necessarily sort of as relevant to this session as it will to the upcoming session, where we sort of talk more about sort of medical information. So some of the key definitions are sort of processing of data, and it just covers almost anything you do with personal data. So it's deleting, disclosing, recording, amending data, and so on. So it's very broad as to what is covered by the definition of processing. And the data subject is the person who can be identified or is identifiable from the data. And then you've got the data controller, who decides the manner and the purpose for which the data is processed, i.e. sort of the how and the why the data is processed. And the controller can be either a controller on his own, or it can be a controller jointly with another controller. And in that regard, both parties decide how and why the data is processed together. And when that happens, the parties need to have an Article 26 compliant arrangement in place, which imposes some extra obligations on the parties to ensure that they are clear about responsibilities when it comes to information giving requirements to the data subjects, but also dealing with data subject requests. And then the final one, and that might be sort of relevant sort of more sort of on the marketing side, if you've got for example, a CRM system, an external CRM system that you're using, who will be processing your personal data on your behalf, they'd be a data processor. And in respect of those, you'd also need to ensure that you have an Article 28 compliant arrangement in place with them, which is just a couple of examples. You just need to ensure that they can only process the data based on your instructions, that you have an arrangement in place on how they can, or if they can, appoint a sub-processor, whether they can transfer data internationally, ensuring that there are confidentiality obligations in the data protection clause, and so on. So there are certain obligations that need to be sort of passed on to the data processor under Article 28. So the UK GDPR confers some rights on the data subject, but also obligations on those who process the data. So I'm just going to give you like a quick summary of some of the rights that the UK GDPR confers on the data subject. So for example, the right to be informed. That would be like, you would usually see that as part of a privacy policy, and I'm going to touch on that in a bit later on as well. But also access rights. So that those are the sort of the famous subject access requests that data subjects can issue, and they often happen in an employment context. There's also got a right to rectification. So if there's a mistake in the data held by the data controller, they can ask for that to be corrected to ensure that the data is accurate. And then also obviously a right to be forgotten, for the data to be erased. The data subject can also request for the data to be processing to be restricted, and the data to be transferred over to another data controller in certain circumstances. So that doesn't apply to everyone, the data portability right. And then we've also obviously got the obligations, and those are just some of the obligations that apply to people who process personal data. So one of them is ensuring compliance with the data protection principles, and I'm going to talk about them in respect of the next slide. But also data protection by default and design. So if there are new processes that are coming into place, that you have a think about how that impacts personal data, and that is sort of thought through at the outset of a project, for example, what data protection considerations need to be taken into account. But also, again, sort of the transparency requirement and ensuring that the data subject is informed about the processing activities that are going on. And also, again, sort of linking to the rights that we've already mentioned, is just ensuring that data subjects can exercise their rights under data protection laws. And then also ensuring that you've got appropriate technical and organizational security measures in place to protect the personal data. And then one of the other sort of key points is if there's a data breach, you'll need to ascertain who needs to be notified, if anyone needs to be notified, and just ensuring compliance with any sort of data breach notification requirements. And then lastly, international data transfers. And as I said earlier, we're going to talk about these in a bit more detail. So the data protection principles, you need to sort of process the data. It needs to be lawful and fair and also transparent. And what that means, you need to have like an appropriate sort of legal basis to process the data. And it can't be like a surprise how you process the data to the data subject, because otherwise it probably would not be considered fair. And again, it needs to be transparent and to the data subject as to how the data is going to be used by the company or organization. And then again, purpose limitation. So if you collect the data for a specific purpose, you can only process it for that purpose unless their further purpose is compatible with that. So for example, archiving in public interest or scientific or historical research would be a purpose that would be compatible with the original purpose. If it is a completely different purpose for which you're processing the data, then consent would have had to be obtained from the data subject in respect of that, or you might be able to rely on a legal requirement to process the data for in respect of a further purpose. And then you should only be processing data that you need. So you shouldn't have you should be sort of the data anonymisation principle should be complied with. So you should limit it where possible to only the data that's actually required for the purpose for which you're processing it. It also needs to be accurate and kept up to date. And you also need to ensure that you don't keep it for longer than is necessary for the purpose for which you're processing it. So for example, where you've got, for example, employment data of an employee that has left, you have to think about how long can you keep that data after that person has left your employment. So you can't just keep data indefinitely. And then again, ensuring that you've got appropriate technical and organizational measures in place to ensure that data is secure. So as part of this sort of the whole compliance requirement is also just having appropriate policy documents in place. So I'm sure you've all come across external website privacy policies that tells you how your personal data will be processed, where the data has been collected from, also if that data gets shared with any third parties. And that will also sort of set you out sort of the legal basis for processing, what your data subject rights are, and so on. And that's usually, as I said, publicly available on the website. And then you've also got the cookie policy sort of that sort of often goes hand in hand with that. And that is obviously if a website uses cookies, then a cookie policy needs to be in place, setting out what type of cookies are being used by a website, whether it's like a session cookie or a persistent cookie, but also you'd also have to have a think about whether and how you're going to display the consent wording for certain cookies to ensure that you comply with the cookie requirements under PECA, which is the Privacy and Electronic Communications Regulations. in respect of that. And there's often a fine line to make sure to be had between sort of having it really detailed, but people are not really reading the cookie banner, or having it too short. So there's quite a lot to think about to ensure you comply with the PECA requirements in respect of that. A data breach policy is always good to have. If there's a data breach and it needs to be notified to the supervisory authority, so here in the UK it would be the ICA, it has to be done within 72 hours of the data controller becoming aware of it. So there's not a huge amount of time for you to decide whether it's a notifiable breach, so a breach that presents a risk to the rights of the data subject. So it's good to have a policy in place that sets out the internal process, what you need to do to assess whether it's a risk that a breach that needs to be notified, and also how you're handling it. In certain circumstances, you'd also need to notify the data subject if it is a high risk to their rights going forward. And I think that's mainly sort of where there's a risk for fraudulent activities, for example, in respect of the bank accounts and so on. And the European Data Protection Board has recently published a very good guidelines on data breach handling, and it sets out very good examples of how to deal with those, especially with sort of from a sort of cybersecurity perspective. The examples deal with those quite well, so that might be of interest. A data handling policy, it just sort of sets out how internally you want your employees to handle personal data. So for example, how do you deal with if they pick up a business card at a conference and so on. That's just internally how you're going to handle the data. The data retention policy, that sort of links back to the storage obligation, that you can't keep it for longer than is necessary, and your data retention policy should set out in detail, in respect of various different types of categories of data, how long you're keeping it for. So for example, if you've got board minutes or minutes of a general meeting, you would want to keep them for 10 years in accordance with the Companies Act. Whereas, as I've said earlier, certain employment data you'd only want to keep for 6 years. And then data in respect of candidates who've applied to your company or organization, you may only want to keep for 6 months after you've made a decision or communicated your decision about whether to get the role or not. So this is a very that's very specific, depending on what data you keep and how long you can keep it for. And then data subject rights. So basically that covers again how you can deal with like a subject access request or any of the subject rights that we've already mentioned. And again, it just helps you have a process in place of how you can deal with those requests within the time frame. You often don't have a huge amount of time. So for example, it usually says you've got to comply with it without undue delay, but or in any event within a month of receiving a request. So it's not a lot of time to deal with a request for information, for example. Although that can be extended if need be. And then you've also got the employee privacy policy. That's an internal document that you keep, for example, on your intranet, and that just sets out how you process your employees' personal data. And that will also usually include how you process, for example, in a consultant's personal data. And then the candidate privacy policy, that again would be an external policy document that, for example, sits on their website if you have vacancies published there, and just explains to the candidate how you process their data in respect of their application. So some of you may need a data protection officer, some of you might not. So it's usually any organization that's a public body or their core activities consist of a regular systematic monitoring of personal data on a large scale, or the core activities involve processing of special category data on a large scale. The core activities and large scale are not defined under the UK GDPR. But if I can sort of just give an example, which might be quite helpful for the processing of special category data, for example, is a hospital processing health data when providing healthcare services to their patients. They would need a data protection officer, whereas an individual consultant or healthcare professional just processing their own patients' data wouldn't need a data protection officer, because that would not be considered on a large scale. Even if you don't need a data protection officer under the UK GDPR, you might want to think about still appointing one or someone who's not a data protection officer and is given a slightly different name, but still a single point of contact, and would usually refer to them as a data protection compliance officer, because then they're not caught within the remit of Article 37. And those are just a single point of contact who will be able to deal with any sort of data protection queries within the organisation as a first point of call. You can appoint a data protection officer even if you're not required to, but if you do, then you need to comply with the obligations imposed on DPOs under the GDPR. So they need to be independent, and also they can't be, their employment, for example, can't be terminated just because they're exercising their function as a data protection officer. So that's just something to keep in mind. And that's why it's important to draw a distinction between data protection officer and the data protection compliance officer who doesn't fall within Article 37. So as I've mentioned earlier, you need a lawful basis for processing personal data. And I've only mentioned a couple here. So one of them is consent. And you can have sort of standard consent or explicit consent. And the explicit consent is important where you have special categories of personal data. And in respect of consent, it's just important that there's sort of no pre-ticked boxes. Consent is obtained in a granular way. So, for example, if you give someone the option to sign up to receive marketing communications from you, you would want to say you would want to have tick boxes for them to tick, for example, by email, by phone, by post. So it just depends. Like, it just needs to be in a granular way rather than just all in one go. Basically, it also needs to be informed. And if you pass personal data onto a third party and they rely on consent for the processing, it also needs to be named consent. And then another one that's sort of very common is performance of a contract. So, for example, if you purchase something on Amazon, you provide them with your address details to get the product shipped to you. Again, that would be Amazon processing that data as part of a contract. And then sorry, too quickly. Third one is legitimate interest. Again, that can be applied by the controller, but also a third party. And that is just, you need to sort of weigh up your business interest with the rights and freedoms of the data subject. And it's important that when you do decide on your legal basis, that you have a record of that you can sort of demonstrate going forward that you have thought about it and your reasoning for picking that specific legal basis for the purpose for which you're processing the data. And I'm sure you've all heard of the fines that can be imposed under the UK GDPR and the GDPR. So it's under the UK GDPR, it's £17.5 million, whereas under the EU GDPR, it's 20 million euros, and it's up to 4% of the annual worldwide turnover. And that sort of relates to the group, not just the specific company. And fines, obviously under the old laws, I think it was £500,000 the limit for fines. But obviously now we've got much higher fines, and they have been increasing steadily. And we've sort of seen quite significant fines over the last couple of years. Even if the fines are not significant, then there's still some reputational damage that can follow from any sort of data protection breaches. So it's important from a reputational brand perspective to ensure sort of compliance. And some breaches also can trigger criminal sanctions as well. So moving on to the marketing and business development activities. So obviously you will have like a list of contacts, suppliers, investors, partners, and people you meet at conferences or a business meeting. And even though they're all sort of business contacts, data protection law still applies to them, to their name, their number, email addresses. So for example, obviously nora.pook@penningtonslaw.com, that would still be my personal data, and data protection law would still apply to that. Where you do get a business card at a conference, data protection law will only apply if you have the intention of filing it, or if you have the intention of adding it to, for example, your CRM system or your computer system and so on, so IT system. So that's just something that's sort of to keep in mind. And how you deal with that data just depends on the category of contact you've got. So you might deal with customers slightly different to suppliers or investors. So it's always worth having a think about, in respect of each category of your contacts, what is the legal basis on which you're processing is. Are you relying on consent, or are you relying on your legitimate interest, and so on? But also, how long can you keep their data? Can you keep it for sort of a more limited time and because someone has sent you an inquiry, or can you keep it for a longer time because it's sort of an ongoing business relationship? So again, it's just something sort of to keep in mind to ensure sort of compliance with sort of those requirements. And then sort of marketing, obviously sort of PECA applies alongside the GDPR, and it's important to consider both of them at the same time. So PECA mainly sort of applies to unsolicited marketing via phone, fax, or electronic means, but doesn't cover post, for example. And electronic means, that includes emails, text messages, WhatsApp messages, but also, for example, if you like a sound or image messages as well. So it's quite broad. Where you're communicating with someone B2B who's not a sole trader or an 1890 partnership, then PECA doesn't apply to any email communications with them. So that is quite helpful, because then you don't have to get consent necessarily as the legal basis to contact them. You can rely on legitimate interest, for example. Where you are contacting a business contact by phone, then you'll need to check the telephone preference services and the corporate telephone preference services, and to ensure that they haven't opted out from receiving unsolicited marketing phone calls. You should also always check your internal opt-out list to ensure that those contacts haven't decided to that they don't want to receive marketing phone calls from you. But consent is not required in respect of those, but they obviously have got the option to opt out from receiving marketing phone calls. In addition, similar to the opting out from receiving marketing phone calls, if you receive, if you send marketing communications to a B2B contact that doesn't fall within PECA, then you still need to give them the option to opt out every time you send marketing communications to them. That is a requirement under the GDPR, and that just needs to be put into each communication with your contact. So we've already sort of mentioned sort of email marketing in quite a bit of detail, but yeah, it could sort of relate to sort of new product services that you want to promote to your contact base, press release about you engaging a new senior employee, a new investment, or any sort of newsletter sign-ups on the website. So it's just important to have a think about who you will be who will be contacted? Do you need to worry about PECA and consent, or do you not need to worry about PECA and consent? So that's just something, especially with the newsletter sign up on the website, to think about in quite a lot of detail, because PECA has the same consent requirements as the GDPR. I mean, these sort of kind of considerations are important, not just from a sort of a compliance with marketing laws and PECA and GDPR, but also if you do or if you are seeking investment, for example, your investors are probably likely to ask you as part of the warranties to confirm that you've complied with data protection laws. So that's where all the previous compliance requirements I've mentioned come in, but probably also that you've complied with marketing laws as well. So, and if you haven't complied, then you've got to disclose against it those non-compliance issues. So over the last 6 months, we've had a lot of changes in international data transfers. We've obviously the UK sort of now the transition period expiring, and the UK sort of having sort of now left the European Union. We still have the EU GDPR applying in the UK, where it has extraterritorial effect. So that means where you've got an establishment in the EEA, or you have customers in the EEA. So if you're selling or supplying goods or services to an EEA customer, then it will apply. Or if you monitor an individual in the EEA, then it would also apply. But I don't think it wouldn't really change a huge amount, because you've obviously got still the UK GDPR requirements, which are very similar. So I think it's just being aware of it and ensuring that you comply with both regimes in respect of that. And transfers from the UK to the EEA. So the UK government have stated that transfers are going to be permitted going forward, and they have found that the EU provides an adequate protection, and you will need to update your privacy notice though to reflect those changes. And then transfers from the UK to a country outside the EEA and the UK, you can do that if they have an adequacy decision. The UK is again accepted adequacy decisions made by the European Commission. So that's, for example, Canada, Japan, Israel. They were subject to an adequacy decision. You can freely transfer data to those countries. If it's dated, if you're transferring data to a country that doesn't have an adequacy decision, it's not within the EEA, then the normal data transfer rules apply. And then you've also got transfers from the EU to the UK, and I'm not sure how likely that is, how likely it's going to apply to your organisations. But if there's just a couple of things to consider. So at the moment, we're in the interim period until the 1st of April 2021, and at which point the UK will become a third country unless this interim period is extended by another 2 months. At the moment, data can flow freely between the EEA and the UK. And we are seeking in the UK an adequacy decision. So hopefully the European Commission is going to grant the UK an adequacy decision, allowing a free flow of data without having additional transfer tools in place. But if this doesn't happen, then the normal transfer rules apply, and you need to implement a transfer tool, which can be standard contractual clauses, which are currently in the process of being updated by the European Commission, or any other sort of transfer tool like binding corporate rules. But again, I don't think that would necessarily apply to you at this point. So there was quite a lot of upheaval in international data transfers, and all sort of started quite a while ago, but the latest decision was in July last year in Schrems 2, when the European Court of Justice decided that the EU-US Privacy Shield is no longer valid, and companies, organizations relying on those as a transfer mechanism can't transfer on that basis to the US going forward. And that meant that they had to find a different transfer tool, such as the standard contractual clauses. But even with the standard contractual clauses and binding corporate rules, it's still it's still been sort of quite difficult to transfer data, for example, to the US at the moment, because the US is not a country that provides equivalent protection to that data as the EU GDPR does. So you have to do a data transfer impact assessment and assess the local laws, for example, in the US or any other country that is not subject to an adequacy decision, whether those laws provide sufficient protection, adequate protection, and if they don't, what supplementary measures you need to put in place to ensure that the data is safeguarded. So that could be organizational measures. For example, you've got training in place, you've got specific policies in place that you flow down onto the other the data importer, or you have contractual arrangements in place with the data importer that requires parties to minimize the data, pseudonymize the data, and so on. And data pseudonymization is also a technical means of safeguarding the data, as well as encrypting the data when it's transferred to for example, the US. But even if all these measures are in place, you still can't guarantee that the data is provided equivalent protection to the European Union. So it could still be held by a supervisory authority, either in the European Union or, for example, the ICO in the UK, that the transfer should not happen and that the transfer needs to stop. And if you do a data transfer impact assessment and you come to the conclusion that the measures are not sufficient, then you should not be transferring the data to that country. And that is sort of particularly important where you, for example, have a cloud service provider. So I don't know whether anyone would be using, let's say, Dropbox or any sort of US-based marketing platform, that sort of CRM platform. In respect of those relationships, you'll need to do a data transfer impact, assess your contracts with them to ensure that any data transfers are compliant with applicable laws. And I think that was it sort of from me. So I know this was a very quick run through what I've sort of just mentioned, but if there are any questions, please let me know.
While other people might be thinking of questions, Nora, you did mention pseudonymization. Do you mind just briefly explaining to people who may not be familiar with that term, kind of what the difference is between that and anonymization? That's all right.
Yeah, sure. So pseudonymized data is still personal data, but for example, if you've got, let's say, usually a name, date of birth, address details, and maybe something else that identifies the data subject. When you pseudonymize the data, you sort of take out some of the information, but the data subject could still be identified from that information, whereas with where data is anonymized, you would not be able to re-identify them. And it's often where it's just, for example, rather than having the name and date of birth, you've just been giving someone the age brackets rather than sort of all the additional information. It's just taking out as much personal data as possible to not allow anyone to be re-identified from that data, or data they can find anywhere else, and combine that with the data you hold. That's sort of the main difference. But I think it's just important to remember that pseudonymized data, even though you've applied a technical means to protect the data, is still personal data.
Maybe a quick question for me still, seeing if others from the audience. So just going back to the data transfer, checking if I understood correctly. So if you are an organization and having data and you, as you said, transferring them to a marketing platform in another country, in the US, for example, you, as the organization, you are liable for this data. So if it's not used appropriately by the platform, that should be them, but still you, because you were the original owner of the data, or how
Yes,
does that
yeah.
work?
So as the data controller, you need to ensure that you've got appropriate sort of agreements in place with the processor. And obviously the data process only allowed to process the data in accordance with your instructions. And if they decide obviously to do something completely different that they're not allowed to do, then you'd usually have, the way you would draft any data processing clause, you have a general obligation requirement to requiring them to comply with applicable laws, and also with the data processing clause. So if they process the data, for example, in breach of that, you'd want to take sort of actions for breach of contract, for example, and also ask for an indemnity if you get fined, for example, as the data controller for that breach by the data processor. But you as the data controller also are responsible for ensuring that the transfer to the processor is lawful. So if you have a US-based processor, you will need to ensure that you have the appropriate transfer mechanism in place. And especially with big companies, they will have on their website usually setting out how they comply with the GDPR. They'll have usually their standard contractual clauses on their website, and so on. And they might also explain what technical measures they've put in place and what other measures they have in place to sort of to deal with the Schrems II decision. But then you as the controller are still responsible for doing the data transfer impact assessment. Some companies might have their own data transfer impact assessments, or a service provider in the US might have their own that they could provide to you. And we've sort of been speaking to clients about that and saying if your customer base is likely to ask for or is required to do a data transfer impact assessment, you might consider having one that you can share with your customers. So don't know whether any of the big suppliers in the US are already doing that at the moment, but it is in the end still your responsibility for carrying out that assessment in regards to the data transfer. But it's just important to have Article 28 compliant wording in place with them if they don't comply with your instructions, and just take the data and do whatever they want to do with the data. Where you can have an indemnity, and then also the transfer mechanism as well.
Thanks. Yeah, I guess that's sort of safeguarding for if you are a small organization, what can you do to make sure you don't go as far as, yes, litigation or other. Can see a question from the audience. Would you be able to share any best practices or you would recommend for managing contacts for marketing or business development? For example, how often should we audit, clear out from the CRM system?
Yeah, I think it depends. It depends on sort of what contact details you have. If you've got potential customers, then you might want to do that on a regular basis. You might want to do it annually, and just making sure that if someone does opt out from receiving communications going forward, that you keep your opt-out list up to date, so that you don't inadvertently keep sending marketing communications to them. I think that's sort of one of the things that people do get upset about, if they've opted out from receiving communications, but they keep getting communications like 5 months down the line. And just ensuring that you sort of keep details up to date. If you haven't sort of been in touch with someone for a couple of years, there's a chance that they might have moved on to a different organization as well, so the data would no longer be accurate and up to date. So that again is sort of one of your requirements on the data protection laws to keep it up to date. It's just it's difficult doing it sort of in a general way, but it just depends on the data. And yeah, keeping it up to date on a regular basis, I think will be best. But you don't have to get sort of reconsenting on like a 12-month basis, basically.
Yeah, and I would add, I don't think there's, as Nora's been saying, there's no kind of hard and fast rules like it must be 6 months or a year. I think it's, as Nora's been saying, it's kind of thinking about what the data is, who the customers are, when you last interacted with them, but also tying it into your data retention policy. If you've got one, it'd be helpful to at least, you know, even if it's kind of short, just in terms of the personal data that you are processing, how long, broadly speaking, you are holding on to it, and then kind of making sure you're actually what you're doing in practice is broadly in line with your policy as well.
Thanks. I think that answers. Unless I think Clara sent the question. Is there anything you want to add? No. But you're right. Probably depends on the size of your database or the CRM system and the type of context you have. And it's probably just a good business practice more than a legal requirement to clean that sometimes. Well, because it's more relevant, but also because you stop pestering people. I can't see any more audience questions. So I would say now is your last chance to ask it, if you have one. If you don't, I think Rachel and Nora are very happy to be contacted or share slides and video if you have anything you want to discuss further. Is there anything you want to add, Rachel, before we close down?
Oh no, just thanks very much, Nora, for the presentation, and thanks everyone for joining. We do hope you found it useful, and please do get in touch if you have any follow-up questions or want a copy of the slides. And you know, hopefully, as I said, we'll be running another session which is a bit more focused on patient data. So obviously, if you're interested in that, please do sign up. We'll let you know when that will be.
Perfect. So yes, I can see some people interested in slides. So what I'll do is, because it was recorded, I'll send the link to the recording in the email probably tomorrow. And maybe for those who want the PowerPoint, so just the slides themselves, just drop me an email and I can send them or actually put you in touch with Nora and Rachel. It's easier. Good. Lots of good comment. Thanks a lot for joining. Thank you, Nora. Thank you, Rachel. And I'll see you at the next one.
Thanks
Bye.